argument next in Case 2249, Lora versus United States. Mr. Rosenberg.
Mr. Chief Justice, and may it please the Court, subsection 924J does not include or incorporate a bar against concurrent sentences. The government admits that at common law and under sentencing law, the default was to allow judges discretion to sentence concurrently or consecutively. The government also admits that standing alone, subsection 924J does not bar concurrent sentences. What the government says is that the bar of subsection 924C1D2 applies, but that bar specifically applies only to sentences, quote, imposed under this subsection. That is subsection C, not another subsection, such as subsection J. And that distinction is compelled by this Court's precedent in Coons-Buick. Moreover, there is nothing in the penalty provision of subsection J that refers to subsection C. Indeed, Congress enacted subsection J as a new subsection, not as a part of subsection C. And it makes sense that there is discretion under subsection J. J1 primarily was concerned with imposing the death penalty for a murder by the use of a firearm and doesn't implicate consecutive sentences. And J2 has a wide variety of conduct from involuntary manslaughter to voluntary manslaughter. The government's answer to all of this is that somehow subsection C is wholly incorporated into subsection J by implication. But that can't be right. Nothing in the text supports that, and it creates impossibilities. For example, voluntary manslaughter with a machine gun has a mandatory minimum penalty under subsection C of 30 years, but a maximum penalty of 15 years under subsection J. They can't coexist. This Court should hold that subsection J means what it says and reverse the Court below. I welcome the Court's questions.
What do you do with the government's argument that seems to suggest that it's simply an accumulation of the penalties, an aggregation or increase of the penalties under C?
It's not just that, and the reason is it defines a separate crime, right? So there are additional elements, the element of a death in subsection J. It's not just an enhanced penalty provision. It actually creates a new crime. And if it didn't do that, you would run into the constitutional problems we discuss in our brief, because you have to have the additional element of a death proven beyond a reasonable doubt by the jury.
How could this have been written to come out in the government's favor from your perspective?
It could have been written a lot of ways. So number one is Congress could have said section C, when in C1D2, they could have said that the bar applies to this section, not subsection. Subsection J could have referred back to subsection C or C1D2 in the penalty provision, which it didn't do. I suppose there are other ways that Congress could have written it as well. I mean, Congress could have included subsection J in subsection C at the outset, and it didn't do that. And it was very important, I think, if you look at the history, that Congress really wanted to make a special emphasis in J that it was doing something new, right? It was adding the death penalty for the use of a firearm. It was adding this really pretty broad variety of conduct in J2 for manslaughter, and it purposely did not include it in subsection C. And so the only, I think, natural conclusion that we can draw is that Congress did have a reason for doing it separately, and we believe that the text of that subsection really controls here.